So, hello everybody. My name is Dominika. I'm an assistant professor at the University of Silesia in Katowice, Poland. And today I have a pleasure to present you one of my latest research on the arms industry. To briefly introduce you to the topic, because some people know a little bit about law, some maybe less about it, public international law. I'm dealing with the topic that is not, on one hand, highly regulated at the state levels. They really care about transferring weapons abroad. But on the other hand, when it comes to the business, evaluating business contact, this is not really from the IHL perspective, from international humanitarian law perspective, not that much regulated. And I will try to rethink, to identify, to diagnose whether IHL in corporate due diligence matters when it comes to the arms industry. And my motives for it, I think, are the same as motives for any research in IHL. So I wanted to, there are armed conflicts worldwide. There are some that involve more fatalities, including IHL violations that concern civilians than others, and how the arms industry corresponds and relates to that topic. And of course, this is something that is very hard to measure because the decisions by business are taken very long before any armed conflict started, but I wanted to somehow measure whether there are any relationships between them. And when it comes to the terms that I will use in my presentation, and I promise I will be short, I will do my best with that, is first and foremost the human dimension, by which I understand, I forgot. Yeah. These are the decision-making processes concerning arms transfers within the arms industry. And my research question, the first that inspired me to dig into this topic, is that do these human dimensions, these decision-making processes within the arms industry, facilitate IHL violations? And I used two hypotheses for that. I guess these are rather falsifications than true hypotheses. So the first one is that state authorization of arms transfers replaces corporate due diligence. I think from my side, and you will see later on, this is a wish that it replaces. And the second hypothesis, that lack of corporate due diligence may constitute a premise of corporate criminal responsibility for example, as not all IHL violations amount to war crimes, not crimes committed during armed conflicts that involve weapons are necessarily war crimes, but I use this as an example. And the agenda for me today is pretty simple. So firstly, I will explain you the terminology used, so the arms industry and due diligence. How do I understand these terms? IHL relevant issues, case studies, and discussion relating to due diligence and war crimes, and conclusions. So I'm pretty open to all your ideas, questions, comments, contraventions, anything that relates to this, because I highly appreciate all of that, including students, of course. So coming to the first. How did you, Kira, did that yesterday, that you managed to operate both PowerPoint here and there? I don't know. So when it comes to the arms industry, the very simple definition would be that it comprises private entities and individuals involved in arms transfers and dual use exports. So sometimes you may find another term used to describe this as the defense industry. But this arms industry is highly related and connected to states for reasons that, of course, transfer of weapons, transfer of arms and dual use export involves foreign interests of states, national security. The arms industry contributes to the national economy because the transactions involve relatively small number of transactions involve great number of financial resources, and not only financial resources. So it's quite difficult to track transactions that relate to arms transfers. And because of the individuals involved also from the state side, it is the discussion, negotiations about arms transfers take part behind any transparency values, I would say, in the sense that the negotiations are hidden because they are protected by collective interest simply. And as Ambassador yesterday told us about tensions between state security and human security, this tension is quite visible in the arms industry. And this whole interdependence with state interests makes this a very foggy environment for corporations to conduct due diligence, even though they want to voluntarily participate, for example, in the UNGP's UN Guiding Principles on Business and Human Rights, and to conduct due diligence, to take responsibility to respect human rights and IHL. And yeah, the second term I will use is due diligence. So very basic understanding of it for the purpose of this presentation is that this is a consideration about what a reasonable action should be to avoid harm or damage to oneself or another person. And when it comes to the arms industry, I would understand this due diligence in the sense that private entities like corporations want to, should and not shall, take all reasonable action during the decision about arms transfer or dual-use export to avoid IHL violations, for example, or international human rights law violations. So not to contribute to harm committed by the end user. And what is important in here is that this due diligence in the arms transfer decision takes two forms. First is the state due diligence. So states naturally, because they have obligations not to assist in internationally wrongful acts, they should ensure that their actions do not also assist in such, for example, IHL violations, including war crimes. And on the other hand, and this is pretty much, let's say, regulated, because we have IHL, we have Geneva Conventions, we have the obligation, state obligation to ensure respect for IHL. And on the other hand, we have corporate due diligence, which is way more complex. Why? Firstly, because this is not something that is considered as an obligation of corporations under international law. These are rather disputed concepts. But in my research, I really wanted to look into the idea that corporations are not necessarily evil in making arms transfer decisions, but they want to adhere to certain standards, and to care about their reputation, not contributing to, for example, war crimes in Ukraine. And furthermore, what is also difficult when it comes to corporate due diligence is that usually state authorization, as I will show you later on, usually suffices for a corporation to go into the specific transaction. So the current state of art is that if a state authorizes an arms transfer, then a corporation believes that the state complies with its due diligence obligation. It does not want to assist in, for example, IHL violations. So a corporation doesn't have to necessarily conduct its own separate due diligence. And the business and human rights framework, with the OECD guidelines on corporate due diligence, the UN guiding principles, Even the EU Corporate Sustainability Due Diligence Directive, they do not necessarily relate to the arms transfer decisions, in the sense that the latter, the EU directive excludes explicitly in the recitals export control from harmonizing the due diligence obligations from the EU companies. And when it comes to IHL relevant issues in here, first, as I mentioned, direct obligations on corporations under international law does not exist or are at least disputable. So a company has to comply naturally with domestic law of the home state, which is inferred from the general principle of the continuity of a state, and the OECD guidelines on the corporate due diligence for multinational enterprises in the general principle 1.2 mention also this aspect. For example, in investment law, which does not necessarily apply here, an investor has the duty of due diligence to know and respect laws of the host state. So most of the discussions about arms industry focus on home and host state obligations concerning, for example, IHL, and not necessarily the corporate conduct in that. And when it comes to the second issue, whether and to what extent IHL applies to business conduct, so in this perspective, we can look into personal, temporal, and geographical scopes of IHL applications. And when it comes to the personal scope, Marco Sassoli argues that IHL applies to all people in all times, and underlies the universal nature of IHL. But when we go further into temporal and geographical scopes, it turns out that, of course, some IHL rules are also applicable in peacetime, but these again refer to the state conduct, to state obligations. For example, to ensure respect for IHL, the rules governing universal jurisdiction or weapons review, if that could be something that might be helpful in our discussion. And of course, the latter one, the weapons review, we can debate whether the customary nature of the weapons review exists in pre-deployment realities, but not all states are parties to the Additional Protocol 1 to Geneva Conventions and Article 36, meaning that the state assessment whether weapons that they are wanting to develop or deploy comply with their other obligations. This is all about states and not all states. And last but not least, the geographical scope. When it comes to war crimes that I selected for the presentation today, you need to for the criminal responsibility under international law, criminal law, you need to provide proof and nexus of this particular conduct, be it the business conduct of, for example, lack of due diligence, in relation to the specific armed conflict. And as I mentioned before, the decisions of the arms industry to go into specific transactions, they are not necessarily linked to that to the specific armed conflict. And in view of Machiko Kanetake and Cedric Gringard, this is something that is disputable, this nexus, being able to prove this nexus between the business conduct and the specific armed conflict to held the corporations responsible. Let's go further. So let me now briefly introduce you to my cases that I selected, but before that, I need to make some methodological remarks. So firstly, when I got interested by this topic, I wanted to look for a coherence and consistency in the cases that I wanted to research. So I collected sample cases from various databases. Like first, if you want to check how states are involved in arms transfers. Then you go into, for example, secret trade registers or other registers, voluntary, like the UN Register of Conventional Arms. But this needs some participation and coherence difficulties. So I based my research on secret trade registers with this in back of my mind that this may not reflect necessarily all arms transfer that took place in between, for example, states, one transferring state and the second that was already involved in armed conflict or was about to be involved in an armed conflict. And there are other portals for Ukraine. You have this War and Sanctions. It works from, I guess, this or last year, 2023. The portal in which it is a database of parts and components and munitions that were detected on alleged crime scenes in Ukraine and the connection to the particular arms company that produced them. So if you like, you can just search how many Western parts and components and EU exported parts and components are found there, used by probably by Russia against Ukraine. But further, I also took into account the UN reports with less trust into NGOs reports and investigative journalism. And I divided these cases, these samples into 4 categories. So first, where there was a transferring company or an individual, it depends. Secondly, there was a licensing body involved, and there were authorized, non-authorized arms transfers. Thirdly, there was who was a recipient, state or non-state actors, and I excluded non-state actors from my analysis, and the alleged links of the receiving state to IHL violations, and there were a potential link or no link at all. And the final samples I selected were those that there was a company, a transferring company, was authorized to transfer to another state, and the latter state was or could have been linked to IHL violations. That was my selection. I'm happy to discuss if these selection criteria were correct. And when it comes to due diligence, I selected. Of course, these cases do not represent the whole spectrum of arms transfers and their evaluation on the in the sense of corporate conduct, but I used them to demonstrate to you how difficult it is to examine the current state of art when it comes to corporate due diligence. And the first case was case brought within the voluntary framework of national contact points of the OECD. The case brought by NGOs against Boeing and Lockheed Martin. And the NGOs argued that those companies failed to take appropriate steps to ensure that their products did not cause or contribute to human rights abuse. This case was selected in the so-called Yemen saga afterwards, where Western states and Western-based companies transferred weapons to Saudi-led coalition for the purpose of their intervention in Yemen. And the result of that was that the Saudi-led coalition conducted indiscriminate attacks. The UN reports indicated that there might be potential origin of industrialized states who delivered some weapons, but the report did not indicate which states were involved in that. And the second claim was a failure to carry out human rights due diligence in arms transfers against corporations. But because this is national contact point procedure, This is firstly voluntary, so it depends on the one hand, the state that adheres to the OECD guidelines providing this due diligence and establishing the state establishing national contact points. And the result of this procedure is specific instance of violation, of the lack of compliance with due diligence, with the OECD due diligence, or the company that complied and the national contact point refuses to examine the case. And the obstacles that were observed when you go through this final document of the specific instance was that the national contact point from the US declared that the use of these transferred weapons must be consistent with the provisions of the agreement or license. That was the basis of the sale or approval of the transfer, meaning that it deals with evaluating state conduct. So the national contact point is not authorized, it's not mandated to consider this corporate conduct. Following that, the OECD guidelines are not state-to-state mechanism, so the case could not be determined. The second one, about Rosoboron export, not challenged, because Russia is not a big fan of anything that goes on in international law. And the potential claim, I try to simulate it, is that since 2011, Rosoboron Export is the only state-controlled company that was involved in foreign arms transfers. In this timeline, exports to the Syrian government were delivered despite, again, reports on the transferred weapons being used to launch indiscriminate attacks. And the obstacles to that are firstly that domestically Rosoboron Export is owned by Rostec, and this is a state-owned company. Secondly, lack of transparency in arms transfers decisions that would allow to challenge these exports to Syria. And national contact points mediation is not available because Russia has not adhered to the guidelines. But we can go into this intellectual adventure and see how, whether if Russia was a party to the OECD guidelines and NCP was eventually established, what would be the result of that examination. And second cases that related to war crimes. This again relates to the Yemen saga. There were a couple of NGOs brought a criminal case against state officials of the export control organ of the Italy. Marco maybe would elaborate on this, on the current state of this case now. Along with that, the case was brought against representatives of RWM Italia, and the claim was aiding or abetting in killing or inflicting personal injury against 6 civilians in the airstrike in 2016. And the remnants of the transferred arms were found on the crime scene of this attack. And as far as I know, the obstacles, and the case was eventually dismissed at the national level. These export decisions and lack of corporate due diligence were legitimized by the public interest, but the criminal court did not really evaluate the corporate conduct. They focused only on the fact that from the mental element perspective of war crimes, the accused state officials acted under the opinions of the other relevant domestic institutions, so it was totally legal. And as far as I know, this case was brought further to the European Court of Human Rights for claiming that Italy violated the European Convention on Human Rights, But I'm not sure what this pending. The case is pending, yeah. And last but not least, again, an intellectual adventure. So here we have transfers of shaheeds from Iran to the Russian Federation, including by these aviation industries. And the obstacle, and additionally to that, again in Ukraine, as I mentioned, there are parts and components for these drones manufactured by and exported by the companies, including from the European Union member states, from the US, Japan, and other states. So here we have two directions. First, against the Iranian companies, and the second against the Western companies that export parts and components to Iran. Somehow it happens that these are found on the crime scenes in Ukraine. And the obstacles to the first situation, the claim by Iran is that these shaheeds have been sent or were sent to Russia before even war started. And even war started from February 2024, but we already know that the war in Ukraine started way before that, in 2014. And Russia rebranded these into its own models. And the second, more complex, is if these Western companies could be held criminally responsible for aiding or abetting war crimes committed by the Russian armed forces, but this link between parts and components found on the territory of the Ukraine, at the alleged crime scenes in Ukraine, and the negligence of the, for example, EU exporters is blurred. So it's kind of difficult to establish that. And yeah, let's now go into verifying how these two hypotheses work. So the first one, does state authorization of arms transfers in fact replace corporate due diligence? And the state due diligence actually depends on state participation when it comes to arms transfer, and in participation in the ATT of 2013, for the European Union member states in the EU Common Position of 2008, and other domestic laws. Every state adopts its own export control laws and provides these criteria to verify that. For Iran, for example, we could only rely on the articles on responsibility of states for internationally wrongful act and state assisting in internationally wrongful acts. So this could be something for evaluating state conduct. But primary, because we focus on home and host state obligations related to IHL risk assessment, this, I think, leads to well, maybe outsourcing the corporate responsibility. I'm stressing responsibility and differentiating it from obligation. Responsibilities in the sense of the UN guiding principles, not obligations as within, for example, domestic law of corporations. And this means that there is some supremacy in arms transfers when it comes to addressing consequences that it has on potential IHL violations. When it comes to business responsibility to respect human rights, so this business and human rights framework, the IHL is mentioned in the commentary to Principle 12 of the UN Guiding Principles. So at least we have something here. That's the advantage of this business and human rights framework. We can debate what are the advantages of soft law and the voluntary adherence to UN guiding principles by companies. If some want to do it, they do it. And what is also important, the UNGPs underlie that business responsibilities under human rights, be it also IHL, exist independently of states' willingness or ability to perform its duties. So independently of corporate or state due diligence, for example. But the minuses of that is that in the context of arms transfers, state authorization in fact replaces the corporate due diligence. That's the sad conclusion. And if companies want, they can conduct a separate due diligence, but they rely on these state-to-state relationships. This is time to finish.
Oh, no, we were
okay. Okay, sorry.
exchanging views for the conversation afterwards.
Okay. And wait. No. Yeah. And secondly, when it comes even to the voluntary adherence to the to creating, establishing national contact points, these even cases are, or specific instances, these are not cases, but these specific instances are hard to proceed because NCPs are reluctant to examine arms transfers from the corporate, evaluating corporate conduct. And but there are some hopes when it comes to the OECD guidelines in human rights applications. There was this case, JAMA International versus Pinfisher, who exported weapons to the Bahraini government, who was engaged in human rights violations there. And the UK National Contact Point actually recommended the company to adapt its due diligence assessments to comply with the OECD guidelines. And last but not least, I believe that the highest threshold, and this applies again to home and host state obligations, relates to the meaning of domestic laws. For example, vigilance laws, due diligence, tort law, in this approaching the arms industry. And last hypothesis, can corporate due diligence constitute a premise of corporate criminal responsibility for war crimes? So first, and this is the most complex issue, of course, not all states provide for corporate criminal responsibility due to some kind of principle under criminal law that corporations cannot commit crimes, cannot be held criminally responsible. But these discussions about individual criminal responsibility are informative to establishing corporate criminal responsibility. So all the lessons that we learned from the contextual element, for example, of war crimes under Article 8 of the ICC statute, and the mental element, all of that apply to individuals, they can form the basis for evaluating corporate conduct, provided that the state domestic law enables companies to be held responsible for war crimes, like in Lafarge case, for example, but for crimes against humanity in that case. So to be short, because I don't want to overuse my time, when it comes to the second point here, the concept of international economic criminal law that Kai Ambos wants to propose to foster, this concept responds to crimes committed by economic actors and not persons in charge of them. However, the other side of the coin is that penalizing arms exporters for the crimes committed by the principal perpetrator, a state official, for example, authorizing the transfer, would be, that's what Kai Ambos argues, contrary to the trust in authorization procedures, because this would lead to some kind of instability under domestic law when it comes to predictability of law, because companies rely on what states say. I last month applied to our export control ministry to ask if my client could transfer within the EU some kind of drones with AI-enabled functions. And the company actually relies on the answer of the export control organ. So they care about their reputation. They care about not necessarily aiding or abetting international crimes. So these trust in authorization procedures are here also crucial. And last but not least, I will conclude these domestic variations of corporate criminal responsibility are also something that we could develop more. As I mentioned, this Lafarge case, where Lafarge was convicted of aiding or abetting crimes against humanity by financially supporting the so-called Islamic State. So this is something that could be verified. And conclusions. So focus on IHL in corporate due diligence is required to enforcing home and host state obligations rather than the company's responsibilities to respect IHL. And I would recommend further research on these domestic solutions to find links between due diligence and the mental element in the corporate criminal responsibility. Thank you very much.
Great, thank you very much. It's really a pleasure to comment on your paper and your presentation. I thought the presentation was really, really good because it's complex and there's a number of moving parts that you're trying to bring together. So I think that responsibility in relation to arms transfer is a topic that is receiving considerable attention, all the more so in recent years. But the focus has been the responsibility of states that authorize transfers. So essentially we're looking at the licit transfers, transfers that have been authorized by the state. That's been the focus of attention, including most of the cases that we are now seeing where there's challenges to a particular authorization. Well, I like your research because it's looking at an additional or parallel dimension of the obligations that manufacturers might have. And I think this is an interesting angle that has received far, far less attention. So it's a very good choice of topic. And I also really liked, particularly in the paper, it came out very clearly, your approach, which is based on case studies. So I really, really enjoyed that. My reaction, particularly reading the paper, was that we need a little bit more work in structuring these moving parts. I always think of writing a paper like Lego blocks, but the big ones, the ones that little kids play with. So in a way, you've got your Duplo blocks, but it's a question of what's the most helpful way of putting them together to make your argument. Because I think you are using tools that perhaps not everyone is quite so familiar with. So one of my first recommendations is a question of structure. So, and I don't know whether this particular article was extracted from a longer piece, perhaps from a book or from a PhD, where you already explained things. But there were occasion moments when I kind of say, okay, I've missed the beginning of this. Where does this come from? And let me give you an example based on the first case study, the Lockheed Martin. Here, the heavy lifting is done by the OECD guidelines for multinational enterprises. And you speak of a specific instance with a US national contact point. And I kind of go, okay, interesting, but I have no idea as to what this regulatory framework is. So it would have been really, really, Hannah's horrified that I have no idea what it is. I thought we were friends and you don't know what it is. I don't know what it is. So it would have been really helpful if you had taken us through it, explaining what these guidelines are. They're guidelines, so I presume they're not binding. What do they cover? Do they apply in armed conflict? What is the purpose of this specific instance procedure, which is what seemed to be relevant in this particular case? What's the role of the national contact point? Perhaps if you had taken us through that first this is the regulatory framework, it would have allowed us, the reader, to understand that particular case most more clearly. And as you keep saying, in a way, the key question that you're addressing is there anything else in addition to any national or internationalized control, export control procedures and laws? And so again, looking back at the OECD guidelines, most centrally to the article, what is the relationship between these guidelines and, in that particular case, the US arms export control laws? Because in my view, it's the arms export control laws that do all the heavy lifting. Is there anything left as part of the process for these OECD guidelines to do? Again, what's the process of mediation? And then I was left wondering, I was saying, okay, I mean, the export control laws regulate the export itself, the authorization of the transfer. Maybe there's something that these guidelines or the due diligence carried out that they could do after the transfer, perhaps, in terms of how the weapons are actually used. So I was looking at, can this particular tool, does it serve a purpose in a context such as the US, where you have the process of authorization, the export control laws? Then from a substantive perspective, and I think you and I are struggling with the same question. And I think that the third case study brings out my key substantive concern. The third case study is the Italian one. And I'm left thinking, if the transfer was authorized by the relevant authorities, what's the point of attempting to bring proceedings against the manufacturers? I just don't understand. They've complied with the law. So what's the point of trying to bring proceedings against them? So we've seen lots of instances where proceedings were brought against the government in terms of judicial review because they improperly applied the relevant criteria. This is what we've seen in the UK cases and in the Netherlands cases. And I think also in Germany, there's cases that are essentially a judicial review of the authorization, but not against the company. And I was kind of struggling to see, how could you go against the company other than if perhaps you knew that it had intentionally misled the government in the information that it had provided when applying it. I just felt uncomfortable saying, why, how could you even initiate proceedings? And Marco, I don't know how they even managed to initiate proceedings and how come a prosecutor even got as far as investigating, but maybe private parties can initiate proceedings in Italy. I'm a bad Italian lawyer. I don't know. I'm surprised the case was even brought. And then a little bit in your general discussion session, I find it a bit difficult to follow what your key concerns are and how to tie them in with the law. And again, it's a question of presenting your Duplo pieces, packaging your Duplo pieces in a different way, because you bring in additional considerations that I don't know whether they are immediately relevant. So, for example, you bring in the obligation under Article 36 of Additional Protocol 1 to review new technology, and I kind of go, okay, I'm not sure how this is relevant to transfers of weapons, which is what I think you're looking at. You know, it's an obligation under IHL, but I don't see how it fits in here. And similarly, the violation of sanctions. Again, I kind of go, yes, sanctions also limit the capacity to transfer weapons, but that's a completely different strand altogether. And to the extent that states have adopted export control mechanisms like the US export control law, like the EU measures, like the ATT, whether the transfer would violate sanctions is one of the key criteria. And if it does, then the state cannot authorize the transfer. So it's not as if it has a separate existence. It's already caught. Yeah, so I'm left thinking there's lots of moving pieces and I'm not sure all of them are relevant. So my suggestion at this stage would perhaps be to take a step back and determine very clearly what it is that you want to address in this piece of writing. So maybe there's things that, you know, if we were having the conversation yesterday in terms of human security, I can see how all the other pieces are relevant, but I'm not so sure that they all belong here. And like you, I mean, even if we focus on the arms transfers, there are procedures for state review and application of applications of transfers. And I'm left thinking, I don't think, which I think is your conclusion, I am not convinced that in a context where there are these procedures, companies' due diligence obligations have a role to play, at least in relation to the transfer. I'm left thinking, I don't think there's a role for them to play, because if they apply for the license on the basis of accurate evidence, then the responsibility, and they get the authorization, well, that's that. I don't see how they can have additional responsibilities. However, an area that maybe where there could be a role for the responsibility of companies would be in terms of illicit transfers. So in situations where a particular transfer hasn't received the relevant approval, there they might be violating domestic law by transferring without the authorization, or if there is no domestic law regulating it, then there is where there could be an opportunity to actually go after the company. So perhaps that dimension, which is the one you haven't addressed. As you were speaking, I wasn't surprised by the outcome of any cases. In fact, I was surprised that the Italian one was even brought. But then you mentioned the Finn case in the UK, and I went, oh wow, that sounds potentially different. I'm not familiar with it, but maybe that might have some dimensions that would allow us to kind of move away from the fact that the state, if a state has approved it, that's the end of the story, at least as far as the transfer is concerned. But maybe the Finn case does open different avenues. So to conclude, I think it is an important dimension to also look at, but you need to find the appropriate situations. So not the ones where you have the approval of the state, because in those cases, I think the company is protected.
Thank you very much. Can I respond?
So yeah, Dominika can respond briefly.
Briefly.
In the meantime, if anyone has a question, please let me know, so always to write on it.
Thank you very much for all this. I'm always struggling with structure and logic, and of removing certain parts of paper and to keep in line. So that's my fault. But I only wanted to respond to the Italian case. I hope we will have some more discussion about that. I believe that the aim of bringing the case against the manufacturer was the strategic litigation purpose, or the NGOs, the ECHR was involved. So I believe that they simply wanted the company to put the name of the company, that there is a case, criminal case pending. So, and this case was part of the broader European discussion about the legality of arms transfers and the liability of arms manufacturers for the transfers of arms to Saudi Arabia and its coalition. So I will only briefly respond to that.
Thank you. We'll start with Astrid.
Thank you. Thank you very much for a very interesting presentation. I have 3 points that I just wanted to mention. So one, I thought at the beginning of your presentation, I was missing the differentiation between individual and corporate criminal responsibility. There was a slide later on where you bring up the subject, but I think this is a very important difference. And interestingly, there are a few states where you have both concepts applying in parallel. Austria, for instance, we introduced a corporate responsibility act, but the cases that are ongoing that would be relevant under the act are before the introduction of of the act. So we are still going for individual criminal responsibility in those cases. And I was wondering, do you see any concrete difference, except for the fact that if we have corporate criminal responsibility, there might be a chance for higher compensation? But otherwise, do you see a qualitative difference whether one goes for the individuals or for the individuals in the context of the company? The second point I wanted to raise was with regards to the mens rea and plausible deniability. Maybe that's not so relevant in the context of authorizations, but maybe when we are talking about components. No, maybe even with authorization. What about circumvening the direct export and you export to third states with or without or knowledge or with or without proof of that knowledge, then that those pieces would then end up in a war zone. And the third point, and I think Emanuela already made this very clear, and I think I fully underline this, that when you have an authorization, a company needs to be able to rely on that. And in terms of criminal law, then you would have a lacking mens rea, because the company trusts the legal opinion, and it would be a very clear case of mistake of law, because you rely on that legal opinion. Okay, thank you very much.
Thanks.
Want to left or you want to respond?
Maybe respond. That would be brief. Thank you very much for this criminal law perspective. I really counted on receiving this kind of questions. When it comes to the differentiation between the first question, between individual and corporate responsibility, if we mean about premises, so for mens rea, for the actus reus, and so on, I think in corporate responsibility, we have multiple actors that make multiple decisions concerning arms exports. So usually there are more than one person that makes a decision on the side of a manufacturer. Sometimes manufacturers cooperate with others to order some parts and components that are then used to manufacture the weapons. But yeah, this is kind of not relevant here. Sorry. So for this part, I would see this difference in the establishing mental element and finding a connection between an act of this manufacturer and armed conflict, if we focus on war crimes, to track all these decisions made before an armed conflict started. But for the practical reasons, for the victim side, so it all matters, the perspective matters. If I would like to examine it from the victim side, then maybe I would try underlying in more detail what victims what is the victim's legal standing in such a case, what is the burden of proof, whether what victims can ask for. So this compensation and alike measures would be more relevant, but I have to rethink this. The second question about sanctions circumvention and export control circumvention, this is a very hot topic, I would say. I talked to Cedric from Utrecht University this summer, and we were discussing about some parts and components from, I guess, dual use being loaded in the port of Amsterdam and then going to the neighboring states, to the Russian Federation, and then eventually we have some parts and components found in Ukraine, how it happens. So this definitely is part, I think, of other for violating export controls. And in Poland, for example, when a company exports without state authorization arms or dual use items, it bears criminal responsibility. So there is this kind of option, and I believe other states have the same solutions. And the last one, I didn't find reliance. What was
the mens rea, lacking mens rea, and mistake of law?
So that
okay, an exclusion.
Yeah, good point. About the links between state authorization and the mistake of law. I have to think of it. I didn't. If you write a paper, there's always a matter of choice what you want to focus. Maybe the scope is too broad, and I should focus only on the war crimes regime, and then go into these specific principles and rules governing criminal responsibility. So thanks for that.
Perhaps thank you very much. I enjoyed your presentation very much. Perhaps just a comment on the Italian decision. It's a little bit more complex because it was brought not only against the management of LWM, but also against the administrative authority, the Italian administrative authority which releases the authorization. It's called UAMA in Italy. It's a branch of the Ministry of Foreign Affairs. So the case against them was related to abuse of power, which is a criminal offense in Italy. And twice the prosecutor asked for the dismissal of the case. For the first time, the judge for the preliminary investigation refused and ordered the investigation to continue. On the grounds that the abuse of power was the main issue, more than complicity in murder, manslaughter, and the real issue was abuse of power. And what happened next is that in 2023, I think in March, the judge for preliminary investigation then dismissed the case after a subsequent request for dismissal by the prosecutor, on the grounds that the specific intent of abuse of power, which requires knowledge to create and undo economic advantage for LWM, or the knowledge to participate in the commission of a crime, that specific intent of the abuse of power was not met in the case. But at the same time, which is the most interesting part of the decision, they made it clear in writing that they believed, the judge of preliminary investigation believes, that the administrative authority had knowledge of the risk and breached Articles 6 and 7 of the APT. So they did put it in writing that they believe UAMA breached Article 6 and 7, but that does not make it a criminal offense in Italy. In addition, abuse of power was repealed. This year, abuse of power was repealed, so it's no more a criminal offense in Italy.
I'm trying to wave the two fingers, but Ido isn't seeing it, so I'll just. So let me understand, because it seems like a strange avenue to pursue to try and get the crime rather than try to do a judicial review. Like they have done in the other states. Wasn't there an avenue for judicial review in Italy?
That I don't know. Probably you have a recourse before the administrative court. Of course, UAMA is a branch of the administration, so it could go. I don't know why
they didn't chew it.
Before.
Other than strategic litigation, crime or something.
Yeah.
But
on the other hand, it didn't go. I mean, From the point of view of strategic litigation, it went quite well, because you have it in writing that, notwithstanding the fact that there is no criminal offense, according to the judge, they breached the UNCT.
Yes.
And then, of course, that is not directly relevant before the European Court of Human Rights, but perhaps it might have a role to play before the European Court of Human Rights. So it's not the end of it.
But that's against the state.
Yeah,
again,
against the state.
so it's not the manufacturers.
Yeah, of course, and that's against the state in Strasbourg. So,
So just to clarify, it's abuse of power by a state agency.
Yeah, because I don't know. We call it more precisely. We call it abuse of office. Okay, it's I guess we have the equivalent in French, but I don't know.
Yeah, it sounds like not carrying your duties according to the law, something like that, right?
Something more. No, it's not just not carrying your duties in accordance with the law. It seems to be something more. No,
it's exercising a public duty with a view to creating an undue advantage to a subject. So that is the essence of the conduct. And according to the judge of preliminary investigation, they did not meet the intent requirement of, because they didn't do it to create an advantage to LWN. So it was a policy decision. It was pretty much in line with the policy of the government, but not to create an advantage to LWN.
Because it's almost as if abuse of power is almost like a corruption-like kind of offence. Well, here we're talking.
But if you read the decisions by the administrative authority, they're very. I mean, there's something. I mean, the way they put it is that they take into account the need to serve employment in Italy and then the economic stability, which is absolutely irrelevant for the ADT.
Yeah.
So, I mean, before an administrative court, I mean, those were issues to deal with. But with a criminal judge, then the issue of intent made it impossible to adjudicate.
For the interest of time, we're going to start collecting also Zid and.
First of all, I really enjoyed the presentation. I think that the issue is really important, and I'm also happy to be the one taking immediately after Marco, because I think that what the Italian case points to is the issue of capture, of agency capture, meaning the country is simply turning to the government to get approvals, clears you of any concern. It ignores the reality in which have agency capture everywhere. Like the regulator that regulates medication at a certain point gets captured by the drug companies. The agent that regulates the arms trades at a certain point will become captured by the arms producing companies. And if you ignore the very common problem of capture and simply allow the law to have each of the sides being rescued by the fact that the other side is involved, it's a problem that must be addressed. And since there's a lot of writing of capture and industry capture of agencies, I think that's a point that should be made in this context.
Mm-hmm.
Thanks for the presentation. Very interesting. For the interest of time, I'll focus on one specific aspect of your presentation, which relates to both the nexus that you talked about and the application of IHL. For you rely on some things that Marco Sassoli wrote, and then, but there seems to be, because later on you talked about war crimes, where there's also the nexus issue that comes up, that there may be a little bit of a conflation, or you don't really discuss the link very clearly between the scope of application of IHL to certain conduct and the potential that the conduct of a company can have a nexus to a violation of IHL. Of course, whether or not IHL applies to the conduct on the ground by a armed actor that uses certain weapons is completely determined on how IHL applies at that moment. And not only the nexus requirement is often a bit misunderstood in ICL, because essentially what needs to be looked at is, was IHL applicable to the conduct at the relevant time? And anything can be, or a lot can be in the context or associated with an armed conflict, but it doesn't mean that IHL was applicable to the conduct at the relevant time. An arms transfer may be associated with an armed conflict, because you transfer a weapon to a conflict zone, but it doesn't mean that IHL is applicable to that arms transfer. So that, I think, that section where you talk about the application of IHL might be useful to really then focus only on, okay, the conduct on the ground, and then you might have to indeed conclude, well, obviously a company in a different country, which is territorially removed from the conflict zone, especially if you have the Nyack, which only where the law can only apply within the territory under the power of one of the parties to the armed conflict. It's fine to then conclude IHL doesn't apply, but that doesn't answer the question whether or not there could be a nexus for the purposes of a crime. And there, the issue that you discuss, you go into aiding and abetting, 25(3) C and D under the Rome Statute. What is a very interesting question, but you don't deal with here, but is generally not really answered, is where the knowledge or the awareness needs to be. If IHL was applicable to the conduct on the ground by certified, should also the direct perpetrator would be bound by IHL and therefore can violate IHL. You can only have a war crime, serious violation of international humanitarian law, IHL fight conduct. But should also the one responsible individual taking the decision to transfer arms, should that person be aware of the application of IHL, at least the circumstances that create the existence of an armed conflict? So that would maybe be an interesting thing to look into. That's not answered by the case law because that's normally skirted over a little bit. And at the moment, everyone is within the same location or part of the same armed forces. For example, the alleged, well, the suspect and the direct perpetrator are both in the same situation. It's fine. You don't need to really address it. But here it really becomes a critical question. So I think that would be very interesting to look at. And that also then becomes important when the mens rea issue that was already mentioned by Astrid in that regard. But on that issue, something that you do refer to the Van Andaat case, the Dutch case. I think irrespective of whether or not you could, the mens rea issue can become an issue if you have government permission. It would be useful to maybe just at least look into how components that relate, the type of component for the type of weapon, because in that case, the mens rea was settled basically by just saying like, well, this component can only be used for mustard gas, and for that reason, it was inherently indiscriminate weapon. So the mens rea issue was taken care of, irrespective of any lack of knowledge where the weapon would be used or in what circumstances the weapon.
You want to respond to anyone or collect?
We can collect and then.
I'm going to be brief because Roger covered many of my points. But Dominika didn't mention it, so forgive me for spilling the beans here. But this is part of the Dominika's application for a Marie Curie postdoctoral fellowship, and I think it's because this piece is extracted from a larger application. Some of the issues have been mentioned. So I know that we touch upon different aspects which have been pointed out by different commentators here in different parts of the application. But my major comment here would be, if you want to turn it into an article, you have to focus on some parts more specifically. I know it's tempting because it puts so much work into this to just tweak it a little bit and have an article out of it. But I think it's too much. It's too much in one piece. So you need to, I think, choose some of the aspects and then dig a little bit further into them. But as of now, it's just a little bit all over the place. And you have people asking questions like, Manu, when was this explained? Or, why some of the concepts were not introduced? Because you had to cut something out, right? So my main comment would be, choose part of the app, which is great. I've seen it all. But then ditch other aspects and focus your piece you want to publish as an article on the, a part of the larger conversation.
I will add one comment of mine that I think the thinking process here is very interesting and the presentation was great, you're basically dealing with one of international law's oldest questions, which is who are the relevant players under international law? And the classic answer is states are the players in international law, and this is where we stand, and this is where Manu's comments and Astrid's and basically everyone's comments are. We are trying to do some kind of a link between states' obligations under international law and corporate liability within that same framework. Now, individual responsibility under international law is not derived from IHL directly, as was mentioned, it's international criminal law. So if the obligation is IHL oriented, it's more of a state oriented obligation. And then we go into what about non-state actors and their obligations, where usually we use international criminal law or the lack of immunity or ability of state to actually capture them. So the fact obligation is of the state, not necessarily of the individual, not directly to the individual player. And this is where actually Magda's comment on the big secret behind the paper is very important, because if your goal is a long research that will actually develop some kind of a stronger liability or accountability towards corporations, then this is, I think it could be more explicit that you're aiming to develop something new in international law. And the more you're going to be open about that concept in your paper, I think it's going to be accepted much better with reader such as Manu, who read and had the basic question. If you had known that this aims to open a big research, you would be more interested to see, okay, so this is where we can push it, and this is where you're trying to attack the question and the problem. And I think that doing that would benefit your article a lot. Again, as yesterday, I don't have a question mark at the end of my.
What do you think?
In this case, it's not even what do you think situation. I do hope that the comments were useful. If you want to respond to any of that, or just want to make sure.
I will only respond with two questions. One side note that Magda also helped me a little bit, or a lot actually, with the first draft of this paper, for which I'm very grateful. And the second, I won't torture you more. You deserve coffee break. So I thank you very much for all the comments. I'm more than happy to discuss them with the coffee in my hand. So thank you.
Thank you very much.